Please get ready for dictation of second part of the Guwahati High Court judgment. It begins from the last sentence of para 5 onwards. The first part was earlier uploaded on 7th April. And please get ready. The link of the High Court judgment is given in the description of the video. 5 seconds now. Start. Charges were framed against both the accused persons under Section 365, 379, 202, 302, 34 IPC by the learned trial court, and the same were read over and explained to the accused persons. But since they had denied the charges brought against them and claimed to be tried, the matter went up for trial. The prosecution case is entirely based on circumstantial evidence. In order to prove the charges brought against the two accused persons, the prosecution had examined as many as 12 witnesses, including the two IOs who had conducted the investigation in the case as PWs 10 and 11, as well as the SI of police of Tejpur police station who had seized the stolen vehicle on 29/3/2018 as PW12. After recording of evidence of the prosecution, witnesses, the statement of the accused persons were recorded under Section 313 of the CRPC, whereby they had denied all the incriminating circumstances put to them. The defense side, however, did not adduce any evidence. On conclusion of trial, the learned court below had convicted the accused persons for the offences punishable under Section 302, 201, 379, 34 of the IPC and sentenced them in the manner indicated above. However, both the accused persons were acquitted in respect of the charge framed under Section 365 of the IPC. By referring to the evidence available on record, the learned senior counsel for the appellants has argued that the corpus delicti could not be found by the IO, and from the evidence on record, the death of the deceased has also not been established. In the absence of any evidence to show that the driver of the vehicle, Santosh Rai, had suffered death, far less a homicidal death, the charges brought against the accused under Section 302, 201, 34 IPC would not be sustainable in the eye of law. Mr. Chaudhary has further argued that from the evidence brought on record by the prosecution side, considerable doubt arises as to whether the vehicle had actually left for Shillong from the house of the owner or from the taxi stand as claimed by the prosecution. The learned counsel for the appellant has also argued that there are enough materials available in the case diary to show that it was the PW6, that is the page number 5/22, owner of the vehicle, who had taken the car to Shillong on the date of the incident, thereby causing a serious dent on the prosecution story. Contending that the accused Jalaluddin, having been exposed to the prosecution witness even before holding the TIP, the process of identification of the accused through TIP stood vitiated. Moreover, the learned senior counsel for the appellant has argued that there was no proper seizure of the vehicle at Badarpur, and therefore it is doubtful as to whether the police had actually seized the vehicle from the possession of appellant Muhammad Jalaluddin. It has also been argued by the appellant's counsel that the prosecution has failed to establish the last seen together circumstance so as to implicate the accused persons. Moreover, the learned sessions judge has also failed to consider the explanation furnished by the accused persons while recording their statement under Section 313 CRPC. Mr. Chaudhary therefore submits that the evidence brought on record by the prosecution is sufficient to prove the charge brought against the accused persons by means of circumstantial evidence, and as such, both the accused persons deserve to be acquitted. Stop.